Hi there, Sandy Steinman here, President of Background Checks Express, your one-stop source for accessible, accurate, and affordable background checks. In our last few videos, we've explored the subject of what it takes to prove a negligent hiring case, and we learned that these cases are very expensive for employers, and we've learned they lose them 79% of the time. We've also explored the subject of negligent retention, negligent supervision, and negligent promotion, and they're equally as dangerous and expensive. But it's sort of like the movie of the living dead. These things just keep coming. Today we're going to wrap up the series on negligence by looking at negligent failure to warn and a couple of other issues that may keep employers up at night, especially if they're not exercising due diligence in hiring. Believe it or not, the duty of care can even become a duty to warn consumers that a former dangerous employee was terminated and no longer worked for the employer. Listen to this. An electronic services company terminated an employee who the employer either knew or should have known had a tendency to be violent. The employee had entered the victim's home on several occasions for business reasons. After the employee was terminated, he gained entry into the victim's home, pretending he was there for business purposes, and he raped the victim. The court ruled that because the employee had been to the victim's home in the past representing the employer, a special relationship had developed between the victim and the employer had a duty to warn the victim the employee was no longer employed. Employers try lots of different defenses to avoid large settlements, and many of them just don't work. Here's an example. Claiming that an employer had no duty to conduct a background check because the employer was not aware of a criminal record or that the applicant hid it or lied about it was rejected by the court, and that's no surprise. In this case, the court held that a janitorial service that did not check backgrounds could be sued for negligent hiring when an employee attacked a college student, and a background check may have shown prior physical assaults on women. The court simply rejected the defense. There was no duty to check since the employee denied any criminal record. Wow, he denied any criminal record. Big surprise, huh? And finally, just as for the continuing sleeplessness, there's no question that one impact of the recent recession is an increased likelihood of job applicant fraud, which means there's an increased need for employers' due diligence. Defending themselves against fraudulent educational claims or worthless diplomas is sort of old hat for employers. But resume fraud has gone to new levels with the advent of services that actually create fake employment references from fake companies. It's scary, but all these issues can be resolved with the right background checking tools in the hands of the right background checking company. As always, I want you to become determined not to become a defendant. You know that employee problems are caused by problem employees, and if you want to avoid these problems, want to avoid becoming a defendant, call me today at 844-SCREAM-NOW, that's 844-727-3366, and let me show you just how easy and how affordable it can be to perform accurate and accessible background checks and to stay out of court. In our next video, we're going to begin to take a look at some of the scariest four letters for employers, the FCRA, otherwise known as the Fair Credit Reporting Act. Wait, Fair Credit Reporting Act? What does that have to do with hiring? Well, stay tuned and we'll find out. In the meanwhile, be safe, hire safe, and I'll see you in the next video.